Great. Okay, so today is October 22nd. We are the Board on Professional Responsibility, and we are in the matter of Mary Chris Dobby and Regan Taylor. These are it's board docket number 19-18 and disciplinary docket numbers 2014-D208 and 2014-D209. Will the parties please identify themselves for the record? Let's start with disciplinary counsel.
Hamilton Fox for the Office of Disciplinary Counsel.
Thanks. For respondents?
You have Amy Richardson for Mary Chris Dobby.
And Alex Little for Regan Taylor.
Great. So we're here on exceptions from both sides. Respondents, it looks like, have more exceptions, so I assume you're going first. Is that your understanding?
That's our understanding, yes.
Okay. Great. As you know, an order was issued earlier saying you guys have 10 minutes each, unless you want to split it differently. How do you want to handle that?
We're actually going to split it differently, if that's okay. We'd like to reserve 5 minutes for rebuttal, and then I'll be taking 8 minutes, and Mr. Little will be taking 7 minutes of our 15.
Okay, makes sense. And who gets the 5 on rebuttal?
I'll be taking the 5 on rebuttal.
Okay, excellent. And I assume you're going first, Ms. Richardson?
Yes, I am.
Okay, so the clock is ready, please. Oh, hang on. Actually, before we do that, I should say, as everybody has noticed, we're on Zoom because of the pandemic. Zoom is good for some things, but really bad for people talking over each other. So I will ask the parties and everybody on the board to please be muted if you're not talking. For those who are arguing, it can be hard for a board member to ask questions, to cut in just because of the way Zoom does sound. So we'll raise our hands. If we've got a question, please keep an eye out to see if there's a board member with a question. And I'll also sort of play traffic cop if it seems like people aren't able to get in. With that, apologies, please, whenever you're ready.
Well, good afternoon. May it please the board, as you know, my name is Amy Richardson and I represent Miss Mary Chris Dobby. Miss Dobby's actions in 2009 did not violate the rules of professional conduct because her actions were reasonable. She acted with the intent to disclose the information that she knew was impeaching to the defense. She believed she was complying with her ethical obligations based on the direction of several levels of supervisors, the prevailing practices, and the state of the law at the time. Both disciplinary counsel and in part the hearing committee ignore key aspects of the factual record and analyze her actions with the benefit of perfect hindsight. The rules of profession, yes.
On that, one of the parts of this that I don't think I understand as well as I'd like is in the Collins report, there's a discussion. It looks like there are 2 lies by Childs. One is in the incident report in response to the inquiry, but the second is the disciplinary charge against the inmate who, was maced. The second one, the disciplinary charge, is not disclosed in the motion in limine. And I'm wondering what's up with that, like why that isn't a separate problem. And I'm not sure, as I read your briefs, I thought the argument was because it's not one of the factual findings on like page 9 of the report. But I mean, is that your argument that just because it's not in the factual findings section, it didn't need to be disclosed, or there wasn't a disclosure obligation? I guess I'm not sure what your argument is as to that non-disclosure of that fact from the report.
Sure. When it goes to the disciplinary report, right? So there was a finding regarding the incident report, and then there's a disciplinary report. There are lots of overlapping things here. So for the disciplinary report, it was just in the investigative section, and Collins said that it wasn't supported by the video evidence. So our argument is that at the time, based on what the practice was and the law was, Ms. Dobby didn't know or reasonably shouldn't have known that that was something that should have been included. She was existing in a period of time where, yes, I'm sorry, I saw a hand up.
Yes, yeah, that's, now my understanding, tell me if I'm wrong, my understanding was that the report did include this false disciplinary charge against the inmate in the Collins report. That was discussed.
In the investigative section, there are 2 or 3 sentences about it. It is not in the finding section. There's not a
So are we supposed to conclude that in acting reasonably, as you said, your client read the entire report?
Yes, you can conclude, and she
Right.
testified that she read the entire report.
Okay, she read the entire report. There was a fabricated disciplinary action against the inmate. She then, am I correct that she had a witness conference interview with Childs, who denied that he had submitted the false disciplinary action contrary to what was found in the Collins report? Is that correct?
And so the Giglio interview, I think is what they call it as a term of art. Miss Taylor, who Mr. Little's client, had that interview, but that was had, correct.
Okay, so I'm going to call it a witness conference because that's
Sure.
my
Absolutely.
terminology. If it was for the purpose of Giglio only, then it's really an oversight, isn't it? That she did she either choose to believe Childs over the Collins report, or did she just decide that she wasn't going to disclose the disciplinary action part of the findings?
So my client didn't have the interview, Mr. Little's client did, so we can speak to that more, but I will say they didn't choose to ignore anything there. They were acting in accordance with office policy at the time, which was, as they understood it, you don't correct the witness or alert them of any issues. And so I think it's also, we all need to understand the circumstances they were operating in at the time. In 2009-
Is that office policy in the record somewhere?
It is. There was testimony about it, in particular from Ms. Taylor. She testified about the policy and what she did in that witness interview. But also in 2009, there was something called the Lewis system that was in effect. So as you know, the DC U.S. Attorney's Office is one of the biggest ones in the country. New people start every 3 to 6 months. And in particular, there's sometimes young or younger AUSAs who don't have a lot of criminal experience. And there are also a lot of officer-involved complaints or misconduct. So they created a system called the Lewis system, where these prosecutors go in a database and they look up a witness. And
is your client saying that she was young and inexperienced, and that's why the board should overlook any? I mean, is that part of your argument, that she was young and inexperienced?
In fact, was unexperienced, but she also was existing in a space where if you look at the elements of Rule 3.8, you have to consider all of the circumstances, including whether she knew or reasonably should have known. And under the system that existed at the time, she could rely on her supervisors. And I'm sorry, there were 2 questions. I'll let you guys.
Yeah, excuse me, Matt. Regardless, or Mr. Chairman, regardless of the Lewis Committee process, it's your client who wrote the motion in limine and decided what to put in there and what to leave out. Is that correct?
That's correct.
The Lewis Committee didn't review that or say yay or nay, that's good or bad, right?
That's correct. But you also have to remember that.
And let me ask one other thing. Isn't there a lot of information in the motion in limine from the report other than the 2 findings? So your client wasn't just guided by what was in the findings of the report to decide what to put in her motion in limine. Isn't that correct?
Mr. Walker, I think the stuff in the motion in limine that are also in the report go to those findings, right? It was some of the language that was in there that went to that particular findings, actually 2 findings.
So I guess the answer then is yes. There's a lot in the motion in limine from the report, apart from those 2 factual findings. Your client picked and chose certain things from the report to put in the motion in limine, correct?
Yes, but she also disclosed the entirety of the report to the court. And I think that's something we cannot lose sight of here. Yes,
Five pages of the report, of a 10-page report.
Yeah, but you have to remember, it's looking at Rule 3.8, it looks at her intent and what she should or knew or should have known. She did not know till after the hearing was over that there was only 5 pages, or was incomplete is a better way to say that. And everyone agrees that that was an inadvertent mistake. So you have to think she's writing a motion in limine to the court thinking everything I'm writing here, the court is going to look at the full report and compare. And on November 2nd, I just want to add this quote quickly. Ms. Dobie said to the court when they were discussing the motion to eliminate, she's reminded the court it had the final report, and she said, and if the court finds there's anything in the final report that should be additionally disclosed to the defense, and if there's anything additional I did not include that would be useful, she's asking the court if there's anything else, I'll give it to you. It shows her intent, not only in the motion to eliminate, but how she proceeded throughout this.
So I think more than half the board has its hand up, or
Yeah.
they had its hand up. So we're going to, I'm going to go me, then Ms. Cassidy, Ms. Sargent, Ms. Pittman, just to have a little bit of order, I guess. So Ms. Richardson, I guess where I am is, looking at the disclosures in the motion in limine and looking at the Collins report, I mean, it's more than half of page 6 of the Collins report that talks about the false disciplinary charge. And that's like 0% of the motion in limine. And it does look like, the Vaughn court talks about this, that could be quite powerful impeachment testimony, right? That you're saying false things about an inmate in order to get them disciplined looks not that different than saying false things about somebody in a criminal trial to get them convicted. And I'm trying to understand why that isn't a 3.8 violation. And I take it your argument is not, because the only thing that has to be disclosed is something that's in the findings page in the back of the thing. That I think would be, you'd have problems there with Giglio, right? That's just not what the law is. So is it that she didn't reasonably know that that was a part of the report because she read it? And I don't know how someone would not reasonably know what's, half of an 8.5 page, half a page on an 8.5 page report. Or is it that by filing it under seal, she's taking advantage of the protective order provisions at the end of 3.8? I mean, and it could be, of course, more than one of those. I guess I'm trying to figure out what the argument is on that half a page of the report that wasn't disclosed.
Yes, Mr. Kaiser, thank you for bringing up the protective order, because we do believe that, and we've argued it. We think that that provision applies, and there was a motion to file or motion to seal that was filed here. But on your point about,
why is that the same thing as a protective order? Because I mean, a protective order, like that was filed after the trial, right? And those happened in when the report was disclosed to the defense after the trial. My understanding is it was still disclosed subject to a protective order. Is that wrong?
so the motion to seal was filed prior to trial starting.
Oh yeah. No, I'm with you.
After the trial was over and there was extended proceedings, remember there were 5 additional hearings and it was held open for a while they were grappling with this issue. The court did say that the Collins report should go at that point. But the protective order, our view is it's not like a capital P protective order where there had to be something written down. It's the opposite. It's not about things not going to third parties, about whether or not something should go to the defense or be sealed. And on November 2nd, when they're discussing the motion to eliminate, the court makes findings about the motion to eliminate that impact whether or not this report needs to go over. So the prosecutors, given the design of Rule 3.8, have to be able to rely on that going forward. But the second part of your question about, I mean, we can quibble about percentages of a page or what's not, is that the system at the time, including supervisors guiding, the respondents here, there was a focus on the findings. And the Vaughn court found that resulted in an unconstitutional result. But the prosecutors at the time thought they were complying with their ethical obligations, as did their supervisors at the time, and did the appellate division that defended this disclosure is adequate at the time. And they didn't have to do that. And there was testimony at the hearing about that, right? And there's also, the respondents said, knowing what they know now, would they have done this differently? Yes, but they were doing it under the system that they thought created adequate disclosure at the time.
Okay, I see. Just to again play traffic help. Let's go Ms. Cassidy, and then send Ms. Cassidy, Ms. Sargent, Ms. Pittman, and then Mr. Hora, if that works for question order. Ms. Cassidy.
Yep, Ms. Richardson, following up on Mr. Kaiser's question, you cite to what your client said on the record about offering to put forward to the judge anything else that the judge may wanted to know. Well, wouldn't the appropriate and reasonable time for her to have done that would have been when she filed her motion, not after the motion? If her intent was to put forward what she reasonably believed the court needed to consider, why would she make that offer after she filed and not with the information, as Mr. Kaiser pointed out, was a substantial portion of the report? Help me understand how that doesn't go to her intent or her lack of reasonable choices at this time.
So my understanding is that she filed both the motion to seal that had the entire, what she believed was the report, final report attached to it, and then the motion in limine on the same day. And in the motion in limine, she did have a footnote where she indicated if there was more that needed to go over, they would disclose. She renewed that request, and frankly, in a way that you would expect an unexperienced prosecutor to do, in court on the day when they were yet again discussing the motion in limine. So she had the intent at the time she filed both the motion to seal and the motion in limine, and then renewed it again in court. So that's how the timing works there. And then Rule 3.8E says it has to be in a time that it's reasonably usable by the defense. And Judge Morin looked at that issue and said, while they were discussing on November 2nd, that there was plenty of time before the witness for them to deal with this issue, which I think complies with that part of the rule.
Okay, Ms. Sargent.
You know, I feel like you're arguing two or three different things. One, that she was so inexperienced that she should be forgiven for all these sloppy mistakes and oversight. Two, that, you know, she thought she was doing the right thing. But I'm interested to know, let's look at this, you know, from a higher perspective here. It looks to me like this is a case where you're relying, the government was relying through your client, on this one witness to identify people who were charged with a jailhouse fight. This is an individual who had made up fabricated facts for an incident report and fabricated facts for a disciplinary action against another inmate. So it's like super giglio. And you're wanting us to be comfortable with the fact that the disciplinary action wasn't disclosed to the court. And how about this? I would like you to answer this question. How is 3.8 impacted by your client, and it was your client's failure to provide the entire report to the court? 3.8, as well as the administration of justice, how was that not prejudiced by her failure to provide the full report? And then again, when asked directly in court by the judge whether he had the full report, to represent that he had the full report. How does that level of sloppiness comply with her obligations to the administration of justice and under 3.8?
Well, I think Rule 3.8E by its very terms requires intentional behavior. And I think throughout the hearing, as well as the decision from the hearing committee, no one has found that my client intentionally didn't send all the pages. I mean, it was maybe a faxing or copying error that she didn't realize happened. And when she went and actually checked in court and took those motions to do it, she went back and looked at her trial notebook, which included what she sent to the court, looked quickly to see what the end was, as we do in court, and saw 5 pages. You could say that was negligent, but it wasn't done in bad faith. And Rule 3.8 is different than a Brady context, right? It includes in it these ideas. You have intentionality, the requirement that you knew or should have known in the rule itself. It's hinged in reasonability.
Not to jump ahead of Ms. Pittman, I'm going to pass it on to her in a minute, but I knew or should have known is negligence. Negligence is faxing 5 pages of a 9-page report to the court, and then when directly asked, not checking your entire file in court with you to make sure all the pages went to the court. That's knew or should have known.
Ms. Sargent, I believe that she did check in court to see, and it just happened to be that the messed up pages were the ones that went, as she took it, put it on the fax machine, she sent it to the court, she took it out, put it in her trial binder. So, and the knew or should have not known part of the rule goes to whether or not something is impeaching. The intentionality goes to the entirety of the rule, and that's the requirement here. And any findings by this board and the Court of Appeals have required that and looked at the standards for that.
Great. All right, so Ms. Pittman, I see, okay, go ahead, Ms. Pitt.
Okay. So where I'm struggling here is in the motion in limine. Well, let me back up. In the report, the investigation report, I think there are 3 things that are problematic for Childs. We have the use of the chemical spray, the use of force that apparently wasn't consistent with policy, because you have the issue of whether or not the individual was in restraints when the chemical spray was used, and did he accurately report that? And then you have that there's an accusation that the inmate was aggressive, which was per the investigation, not consistent with the video and the other evidence. Now, I get that the findings that are listed on the last page do not include an explicit finding that Childs accused someone of aggressive behavior, and aggressive behavior was not found. But there is an express finding that the inmate was not aggressive. It might be related to the other reports that were filed from the other individuals, but you do have an explicit finding that upon reviewing this inmate did not act aggressively, or at least that's not consistent with what they saw in the video, etc. Now, if I were a prosecutor and I'm prosecuting an assault on an inmate, and one of the key things I need to establish is that the inmate, or an assault by an inmate. And one of the key things I need is to identify the inmate. And the very person who's going to do that for me, I now have a report in my hand that he has accused an inmate of being aggressive when he wasn't. That's the thing that I think would have caused me, when I got the report, to go, oh no, this is Brady material or Giglio material, and I need to do something, and I need to talk to my supervisor. And yet somehow that disappears from the motion in limine, and instead you have a summary that a block quote of what the officer claims occurred, despite the explicit finding that the inmate was not aggressive. How do we deal with that when it seems to be that the summary in the motion just seems so divorced from the investigation report? How do and I know that's a very long question and I apologize, but that's the thing that I'm struggling with, is it just seems so divorced from the investigation report and the prosecution that's actually occurring. And how do we not get some level of, she should have been triggered by the questions in court that didn't involve inmate accusations being false, or accusations about inmates being false?
So if I don't address every part, please let me know, but I'm going to start with your instinct where you were like, well, I would see this and think it was something. Well, that's what my client thought, right? As soon as she got this, she went to her supervisor, who then sent her to her supervisor, who then sent her to the Lewis committee, who she continued to bug to try and get an answer on how to properly disclose this, knowing that she's used to a system where she goes to a supervisor and they either say, here's the disclosure, or give it to the court and disclose and litigate it, right? So she goes through that process, and what comes back to her is a lot of what you see in the motion in limine from John Roth, who was at that point the chair of the Lewis committee. Are you coming off mute? Yeah.
Well, so that's my concern, is I do feel like the thing that should have triggered the concern is the false accusation against an inmate, because that's the very case that she's prosecuting, an accusation against an inmate. And so how did that get lost in the wash, that the motion in limine doesn't mention it at all? And how do I treat that absence when it comes to intent?
Well, and we have testimony at the hearing that because of the direction they were going, it just didn't occur then, because the way it was put in the investigative section, the way it was phrased, the way their supervisors were treating it, that is what, it didn't elevate it. But then when they had concerns, right, they gave the whole thing to the court, or they thought they were, right? There was a understanding of our intent is to disclose. This is what we think is proper based on looking at the law, getting the sample motion, talking to our supervisor, bugging them to get response. But we're also going to have a safety net. And that safety net is going to be giving it to the court, which Judge Moore and the judge at the time testified was common in general at this time, but also common in this case. Discovery was going to him in this case before the respondents were involved and even after, to get his view on what should be turned over to the defense. So that has to influence your view of how, if you are that prosecutor, of your disclosure and how you're doing that. And then it's represented in real time, both in the motion in limine footnote and also in what Ms. Dobby says in court, right? And that's the difference between looking at this in a Brady setting and looking at it in a 3-point-E setting, right? It has intentionality and requires that reasonableness in it, in the rule itself. And having looked at 3.8E cases and Brady cases, you can imagine I've read a lot of them over the last few months. I cannot find one where intentionality is found when the thing that's at issue has been given to the court, right? Because it seems an express intentionality of, I want to get this right, and I've sought direction and done the things I thought I should.
So
did I answer all parts of your question?
Mindful that other people have had their hand up and I'm jumping the line and we're 29 minutes into an 8-minute argument. I guess the problem, the concern I'm worried about with your argument as expressed right there, it kind of goes into, one of the other big problems in the case that we haven't really talked about, which is what we do with the Court of Appeals opinion in Vaughn. And I get the collateral estoppel arguments that, we're free in some sense to disagree with the court's conclusion in Vaughn. But the court really describes the motion in limine in pretty stark terms, that it presented as true that which had been determined to be false. That looks a whole lot like, dishonesty, like 90% of the way towards a dishonesty finding. I could see your argument if your client had accurately and fully described the report in the motion in limine, or perhaps if your client had not described it at all. But it looks like what the Court of Appeals said, and said for some reason, is that the description of the Collins report in the motion in limine was false, and as the hearing committee found, recklessly false. I guess I'm wondering if your argument doesn't get you out of the 3.8 problem and like squarely into the 8.4C problem. Does that make sense?
Yeah, can I answer two things on that? I'd like to talk about the impact of Vaughn and then about 8.4 also. Listen, Vaughn by its own terms says we're not looking at the good faith of the prosecutors. That's not our job, right? And it was on a different factual record and didn't look at the intent or good faith. So I think that just is clearly what you guys are charged with doing, is looking at it in this setting. And when it comes to reckless disregard, my reading of reckless disregard is of an apparent risk. And not to keep harping on the fact that these prosecutors thought that the judge had it, but that's the apparent risk part, right? They didn't think there was an apparent risk of being dishonest because of the safety net that was created. It's critical here because of the way that they're being trained and what they're doing. And they're thinking, okay, I've done what I'm supposed to under the Lewis system. I went to my supervisors. I've done a disclosure that's much more than anything I've ever done in the past. And I've given the court what I believe is to be the whole part of it. And if you're looking at reckless disregard of an apparent risk, you have to look at the apparent risk here. And they don't see an apparent risk. They're not disregarding it thinking, oh, well, the court will never understand this and make a bad ruling. They're thinking the court's going to be looking at this in real time and making an evaluation based on everything that's there. And I've done what I think I need to disclose. But again, I've asked the court to make sure it's adequate.
Mr. Hora?
So there's two questions I wanted to ask you. I mean, the decision to give the motion in limine to the judge along with the attachment, but not the attachment to opposing counsel. I mean, judges are busy people, right? They have to thousands of cases that they're handling or whatever. Why not give it to opposing counsel? Why not get a protective order if there was some issues about employment? Or other, employees or so forth that might be, confidential. And the second question that I'm going to ask Mr. Little as well is there any distinction that we should be making between the conduct of your client versus the conduct of Mr. Little's conduct, the conduct of Mr. Little's client?
Yeah, I'll start with your first question, if that's okay, just kind of
Yeah.
about you know, I do imagine that Judge Moran was overtaxed. He'd probably like me agreeing with that. But this was the common procedure at the time. And I know at least my client has testified that no one raised the idea of protective order with her. She'd never used one before. That wasn't kind of an understanding of her. She thought that you did that through a motion to seal. And she did have concerns about the sensitivity given how these guards functioned in this case, that they were still guarding the same people who were on trial given the nature of this. And we're concerned about them using it for leverage. I mean, she has testified, like, if she could do this again, that she, knowing what she knows now, would do it differently, but she didn't know it at the time. And that goes to the known or should have known standard. And as far as the distinction between my client and Mr. Little's client, you know, they were both signing the papers. They both were on this case. They served different roles. We leave that to the board, but we don't see a distinction between what they did here. Neither of them had the intent or the required knowledge to violate 3.8 or the other rules that have been charged here.
Okay. Absent other questions, we'll turn to Mr. Little. Great. We
Thank
have, what is it, 7 minutes on the clock? Actually, if you could, let's get that up for you, Mr. Little, and then, okay, great. Whenever you're ready.
Thank you, members of the board. As I said, I represent Reagan Taylor in this matter, and I want to jump right into this back and forth. I want to answer the question that Mr. Kaiser had and Ms. Pittman had. The reason that secondary collateral, maybe falsehood, that is described in the report would not have made it into a more prominent position is because under the law at the time, it was not admissible impeachment. It would have been collateral. And I can give you a good example for that. The places where I practice in these courts.
One thing I don't understand from your pleadings is it the case that it has to be admissible for it to be Brady? I mean, if you had, you know, if a witness had inadmissible hearsay that said that someone other than the defendant committed a crime, why would that, I mean, I just haven't looked at the Brady law, but
I can answer that briefly. It's because it's
on that, right? You're just assuming that if it's inadmissible, it's not Brady. And I mean, I'll do the research, but I don't think that's the law, and that's not in the language of 3.8.
Because it's not Brady, Mr. Kaiser. It's Giglio, and so it's different.
Sure,
but that's an important distinction because what you could impeach on and what you couldn't impeach on would determine your disclosure obligations at the time.
Mr. Little, I'm sorry, Mr. Chair, are you still in your colloquy?
You use it as the basis to do an investigation and find information that you could impeach on. Right, just because you can't impeach on the document itself that you get doesn't mean that you couldn't do some investigation and impeach on it. The allegation is that the officer, the child, made a false statement in a report trying to get disciplined. Like a false statement is a false statement, and you can impeach on it.
You can't.
Let me just, Mr. Little, before you go on, I really take issue with your characterization that the question of this fabricated disciplinary action, filing a report that an inmate was aggressive when the inmate was not aggressive, that is a species of Brady for impeachment purposes. You couldn't have a relitigation of that disciplinary action, but you can certainly cross-examine the witness with regard to that false report. And the cross-examination would be, you're here now testifying that my client is on that tape. You are identifying him as being part of this melee. But in fact, isn't it a fact that you once falsely in an official document, falsely accused an inmate of being aggressive, and there was an investigation and a finding that the inmate was not aggressive? So
that is the law today.
It has been the law since Brady, Giglio, and a species of Brady for impeachment purposes were ever on the books.
So I want to dispute that, and let me tell the board why. The judge who handled this matter, Chief Judge Moran, is the Chief Judge of Superior Court. He knows the law of the DCCA as good as anybody who's doing this, and he determined that this was not a ground that they would be able to ask questions on, and therefore the failure to disclose it was not a violation of Brady because it wasn't proper Giglio. Now, the disciplinary...
You can rely on Judge Moran for good faith action. You can say he made this ruling, but I would not characterize him as being the unimpeachable. If that was in fact his ruling, that's not you can't rely on him as if he were the legal scholar on that point. you
Why
can
don't,
him for good faith. But
let me maybe ask something close to what Bernadette's asking in a slightly different way, which is it looks, I mean, the Vaughn court, when it talked about that exact same evidence that Judge Morin ruled on, said it was not a close call about whether
Right.
it would be. And I don't, and it doesn't, yeah, I mean,
So there's record evidence about this. This was discussed at the hearing, and Chris Ellen Kolb, who was one of the chiefs of the appellate division, talked about what a sea change the Vaughn opinion made upon the way they handled these sorts of materials and these sorts of considerations. They were not generally understood especially in the U.S. Attorney's Office, but at least in that courtroom, to be the sort of materials which would constitute Brady Giglio or Giglio that constituted Brady. Yes, Ms. Pittman.
Well, I read her testimony a little bit differently, which is that when posed with a hypothetical, the hypothetical being that you've got this accusation against an inmate as being aggressive that turns out to be false, and then you're prosecuting this case, would that be something that you would need to produce? Would it have been enough to have summarized in a motion in limine, but leaving that out? And she responded that it should have been put in. And so I don't know that her testimony gets you as far as you want, which is to say that that would not have been disclosed in 2009. I read her testimony as it should have been disclosed in 2009.
I think what she said was it would have been the safer route to do that. I think her testimony is clear that that was not the sort of impeachment that was permitted under the rules at that time. And I think it goes back to this question of, to the extent that we're talking about whether a misrepresentation is made in a legal filing to the court who has the actual source materials at issue, this would absolutely be an unprecedented decision to come out and say,
it's not a misrepresentation to the court, it's a misrepresentation to the defense.
and
We
I understand
have
that.
an adversarial system, right? The defense gets to go in and argue, hey, judge, we should get this. And if the defense has bad information, they can't argue well. Like, that's not how we do criminal cases, where the prosecutors give the evidence to the judge and say, hey, judge, let us know what you think.
Well, with all due respect, Mr. Kaiser, the testimony of this judge was on these sorts of issues. Material was regularly handed to him, sometimes summarized as short as a sentence. So a whole report would go to the judge, and they would say to the defense, hey, we've got this disciplinary report, we're giving it to the judge to determine whether or not, and that's not the way the law is today.
No, I hear your argument on that. Where it gets harder, though, is when the description, and look, maybe the Court of Appeals was wrong when it looked at the motion in limine and it looked at the Collins report and said, looking at these two documents, we think this is this presented as true, which was false, that which was false. But if that's a false characterization, a false statement to the defense about what they're giving to the court, it looks like that. The independent false statement, I have trouble with, regardless of whether the court is getting the document.
I think the best sort of evidence we have about that in time, remember, we're 10 years past here. We are looking at a record that is very different than it was at the time. Judge Morin spent 18 months dealing with this issue. He looked at it in depth. He had multiple hearings on it. He was the closest to this evidence at the time. There was nothing in the hearing panel below. No evidence whatsoever that they relied upon or found in the fact in this ad hoc committee that these two individual prosecutors intended to lie. That was not their conclusion. And I think what you can say is it would have been an incredibly bald-faced and bold attempt to lie to the defense counsel about a document you give the judge and just hope the judge didn't notice. I mean, that beggars belief. It beggars belief, and it's not consistent with everything they did to get this right. I mean, we were focusing on whether one paragraph or one half page was properly summarized. We had a week-long hearing where we detailed all of the steps that these prosecutors took to try to do the right thing. And it would be, oh, I'm sorry, Mr. Walker, I'll stop.
Thanks, Mr. Little. So if the respondents do not intentionally provide a materially incomplete motion, account of the facts to defense in this case, if it wasn't intentional, why did they exclude the information that they did exclude? And if the answer is because it was consistent with what their supervisors told them to provide, which Ms. Richardson argued, can you point to me exactly in the emails from the supervisors where they say you disclose this and don't disclose that? I mean, if you're falling back on the supervisors, telling them this was adequate and this was the way to go, where exactly is the email that instructs them, here's how you present it?
Well, I think the evidence in the record from Mr. Ragsdale was that he gave them an example motion. And then he also told them sort of go do this. And the record also was clear from all of the witnesses from the U.S. Attorney's Office. And having been there myself, it is a zoo. And I think that the hearing committee's, the hearing committee's admonishment of the lack of supervision is entirely appropriate.
There are others here who have been there as well. So I'm not sure a zoo is a technical term, but to go ahead.
Well, I think we'll just say they're not potentially enough caretakers watching what's happening all the time. And so what you got mostly was not emails. You've got this back and forth oral communication and telling them what to do.
Excuse me.
Yes, Ms. Cassie.
Excuse me. Mr. Earl, can you answer this for me? Whether it's a zoo or not a zoo, and regardless of how many supervisors your client had overseeing her work, is she not a licensed lawyer with her own discrete responsibility to understand the evidence that she has, both exculpatory and inculpatory, in a case before she goes forward with that prosecution, and then proceed accordingly, consistent with the United States Constitution and her professional obligations, regardless of whose supervision? Can you answer?
100%, absolutely. And we're not saying, I mean, that's what she did. They repeatedly followed up with the Lewis Committee. They provided what they believe was the complete report to Judge Morin. They wrote a motion in limine about it. And then it's all these matters sort of to unfold about the fact that there had been not all the papers provided. They immediately said, okay, Judge, we'll get you what you need. These were not folks who intentionally neglected these obligations. And so when I talk about the supervision issues, what I'm trying to respond to is Mr. Walker's question about, well, where is that in there? And I think the reality is it's being done in a very ad hoc, I see in the hallway, what should I do about this? And it may be a 30-second conversation about that case. And that's what the record shows. I mean, I think what's important here about our views as to what should have happened is there is a week-long record, and nowhere, and I think this is a critical omission, nowhere in the record does disciplinary counsel provide a single prosecutor or expert or anyone who's worked in criminal justice at that time who said that what was being done unreasonably. And I understand that, I think particularly because we're talking about some questions here in the law that are undetermined. And, I know that Mr. Hora had a question about why didn't they do X? Well, there was a discussion of the things that were done regularly. And what Mr. Hora described was not something that was done or trained upon or under Judge Morin's testimony regularly occurred in his courtroom. And so I think the factual context, we cannot separate what was actually going on from the facts in the record. And I think that's an incredibly important dog that does not bark here. These are not prosecutors who said, I know I'm supposed to do this, I was told to this, and I don't. That's not what happened here. Mr. Kreiser, you had a question or?
Yeah, I just wanted to make sure, I know we're not going to hear from you on rebuttal. I just wanted to make sure, I think you may have touched on this briefly, but if you see a difference between your client and Ms. Richardson's client in terms of the conduct or any of the issues here, if there's any daylight.
I mean, I think it's difficult on the record that we have to determine. I mean, I think, again, we don't believe either of them harbored an intent. This would be an opinion unlike any other that says if you give the judge the full document, I understand there's a talking about the motion to eliminate, but again, the judge is presiding over this. He's got a copy of that. He knows all the facts here to find.
Let me ask you this in a different way then. We've spent a lot of time talking about the motion in limine and talking about Ms. Dobby's work, reading the Collins report and summarizing it in the motion in limine. What's the record evidence on your client's role in putting together that motion?
I think she read it when it was done, and she had read the Collins report beforehand, and she knew what, and she believed it had all gone to the judge as is, and she did not dispute what was there. I do want to respond.
I want to ask you one question about 3.4D. Do you feel like just because your clients fully disclosed, did I cut someone off? I'm sorry.
Go ahead.
No,
I'll
I'm
come
sorry.
back for you.
Go ahead, Ms. Pittman. No, I
No,
will
no.
go after you. No, I was just going to ask about 3.4D because we keep, it seems like both respondents are hanging their hat on the fact that everything was given to the judge, even though the fax was cut off or whatever. Do you feel like there's any issues though with respect to 3.4D where you have a duty of fairness to opposing counsel, regardless of whether or not the judge got the motion in limine and could have decided it that way?
So 3.4D specifically relates to discovery obligations. I think it's our position, and I emphasize this, that 8.4, that the 8 rules sort of supersede on that point because it is a more, and I deal with this in my reply specifically if you want to look at it there, that the specific obligations on a prosecutor supplant the 3.4D obligations on discovery, because particularly if the allegation is about that actual topic. And so 3.4D doesn't reach anymore.
How does it supplant? I don't understand that argument. Can you explain that to me?
Sure. So I quote this, the second or third comment to the rules talks about that there are some rules that in specific cases apply more specifically. And in those cases, the general rule should not be read to apply additional obligations beyond the specific rule. We deal with this in, I think, the second or third pages, like page 2 to 5 or 3 to 5 of our reply. And so here you have a specific rule that does not apply to defense counsel, that does not apply to civil litigants, that relates to discovery around Brady or Giglio materials. And that the question under 3.4D is that, whether they're complying with a reasonable discovery request. And so that one is sort of supplanted by the original obligation to provide exculpatory material.
Well, presumably, sorry. Go ahead, Ms. Pittman.
I promise my question will be shorter than what I did earlier. My question is, we know that the judge did not receive the full report. So the early rulings that are made prior to him receiving the full report, can we rely on those in any way in terms of sort of representing fairly whether or not the disclosure obligations were met here?
Yes, and one of the questions, if you
And
look
why?
back, well, first, if you look back at the transcript of the hearing, one of the things that the hearing panel left us with was a question to brief whether those pages had been received or not would affect the outcomes. There's specific briefing on this question in the record. We talked about that in detail. If you want to find a more reasonable response, though I can give you very briefly here. But because these rules relate to, and ethical rules have to relate to the state of the mind of the individuals and the actions they took.
No, I understand that. What I guess my question is, it seems like you guys are relying on a lot of the judge's rulings as kind of a safe harbor. And so my question is, when it comes to the trial judge's rulings, those earlier rulings are without the benefit of having the full record. And I think that the Vaughn court points that out, that you can't really rely that much on the trial court ruling when he only had half the report.
I guess, Ms. Pittman, the question is, what are we relying on it for? So in the beginning, I think why he has the 5 pages, they believe he has 10. I think we're trying to explain that they are reasonably relying on the safe harbor provision of protective orders, which certainly there's no case law to suggest it has to use magic words to be a protective order. And there's absolutely record evidence indicating that that's what happened on a regular basis. Whether they called it protective orders, it was certainly an order protecting disclosure. So in the first half, before he gets the 10 pages, our reliance is on that safe harbor. When I talk about, he does get the full report and he still makes determinations about what would have been necessary to disclose or not pre-trial. And so
is the Vaughn court correct that he got the full 10-page report, but not the appendix?
Yes, that's correct. At no point, and let me talk briefly about that. This is a great example where there's no record evidence that any prosecutor would have or should have received that appendix at that time. I mean, I think that they say, hey, later on, Vaughn clearly was concerned about that. But at the time, there's not a similar case. There was certainly no suggestion from any of the supervisors or any of the witnesses at the hearing that they should have done that. And it's again where instead of actually relying on record evidence, we have this post hoc sort of, hey, perfectly, here's what you should do now, and know what we know now. And I don't know if that answers your question, but I hope it does. And Mr. Kaiser, can I, before, if you're going to cut me off, one last piece.
I was going to cut you off. Take a few seconds, wrap up, and then we'll.
There was, I think, well, actually, on the record basis, he did get the appendix at the end, Ms. Pittman. I apologize. So at the very end, he did have the appendix, and he came up with the same conclusion. So I see Mr. Richardson's correcting me there. We have a huge record here, but that's right. He did have it at the end, and came to all the same conclusions based on that appendix. The other piece that's been mentioned briefly, I know somebody had a question about it and I didn't get to respond to it because it wasn't my time, was about the Giglio interview and the purpose of that. And I think what's important there is the record evidence, both from Chris Ellen Kolb and from my client, was the intent is not to investigate the actual facts. It's to understand what the knowledge and the state of mind of the witness is, because that determines some of your obligations about.
Mr. Little, that was actually my question.
Yes, Ms. Sargent.
One thing that does concern me is the witness responded to her in this witness conference, Giglio conference, if that's the term of art that's used, falsely. And so what was done with that? So now you've got, is there anything in the record about what was done with that, or was it just?
Yes, in fact, the way that he responded to her is the way that he responded to the judge on the record. I mean, I think that it was his actual understanding of what he did. So it wasn't as if his response was somehow hidden. He changed his story, and then she knew that he was telling the judge a new story. It wasn't that at all. When he was actually voir dired about this, he gave the same answers to the judge as he gave to my client. And so I just want to make sure that factual point made it.
Okay, and just, I don't want to take up a lot of time, but just, and so we're saying that it's okay that are we saying that this was a misperception of this particular witness?
And that was the judge's conclusion at the end of the hearings, yes.
Mr. Little, why don't you take a few seconds and wrap up, and we'll hear from Mr. Fox.
I understand the board's desire to, right this wrong. And that's what the DCCA did in reversing these convictions. But what we're here to do is determine whether or not these two individuals committed an act which was not ethical. And I think if you look, what's incredible about this appeal is that there is not a fact in that hearing that the hearing committee found that we dispute. What we're talking about today and what we're arguing about is whether what they did was appropriate or not. And there's lots of opinions about that. But if you go back to the time, 10 years ago when this occurred, they acted in accordance with the practice of that court, not just their office, but the practice of that court. And I can tell you, as someone who sat there, and I think as anybody who might reasonably be a young attorney wondering what to do, that judge may be busy, but you rely on that judge every day to make the decisions. And if you give the judge the full report, yeah, maybe you aren't so careful about how you describe it. And maybe you aren't so careful about different parts of it. But you know that your obligation to make sure that the court gets to make decisions about the fairness of trials is done. And this would be the first time an ethical board in this country that we've been able to find would find an intentional violation of Brady, of the prosecutor's obligations under Brady. But when a prosecutor did not lie to the court and gave the court the underlying source material that's being talked about. I think this may be, a case that calls for all sorts of discussion of the relevant facts and standards going forward. But at the time, these two prosecutors did their best. May not have been as well as some could have or should have, but it was not an intentional violation of the ethical rules.
Thanks very much. If we can have 20 minutes on the clock, and then as soon as that's there, Mr. Fox, whenever you're ready.
Mr. Chairman, members of the board, I want to make 4 points today about Rule 3.8E. I was going to begin by emphasizing the difference between the incident report that Mr. Childs made, which was the one in which he falsely said that the inmate was handcuffed before he sprayed him with mace, and which is what the focus was on before Judge Moran and before the prosecutors before the trial, and the disciplinary report, which was the false report that he made that the inmate committed an assault. But I think you have that point. And so I'm not going to dwell on that, but I would add 1 point to, I think it was what Ms. Pittman said when she was indicating, I think she said 3 problems in the Collins report. There's an additional problem, and that is that not only did he make the false disciplinary report, but he was supported by 2 other officers who also made false reports, which seems to me to make his conduct even more impeachable. Now, I said I want to make 4 points. The first,
well, on that part, let me, because here I get, I mean, you know, you heard the exchange I had with Mr. Little about admissibility and Giglio and Brady, but I guess it strikes me as a little bit the conspiracy at the jail to set people up part. I'm not sure how far that goes as a Brady Giglio violation, that he's enlisting others to make false reports. I guess I'm not. Can you say more about why that would be really bad? That would be really impeaching.
It just seems to me the conduct is infinitely more reprehensible if you not only made a false report accusing someone of committing an assault, but you got two of your colleagues to also issue false reports. I mean,
and we don't have any, there's nothing in the report about who got who to say what. It's just that 3 people were saying the same thing and it wasn't true.
Right, absolutely. But remember, and you made this point, I think, earlier in one of your questions, and I'm going to come to this if I can get my next point in a moment on the text of the rule. But what has to be disclosed is information, not evidence. Evidence has to be disclosed as well, but it has to be disclosed as information so that the defense can go ahead and investigate, and it has to be disclosed to the defense. And a defense lawyer seized with that information might well have been able to do something with it, that this was more than simply one officer making a false report. He went out and got his friends to corroborate it. Now, where I want to go here,
Mr. Fox, I just want to. So at the time that the incident reports, the false incident reports were submitted, lieutenant, correct? Because his discipline was he was reduced to sergeant. So it's lieutenant, and the ranks of the other people, I don't know if they're in the record or not, but he had a high rank and was part of the grouping of these incident reports.
that's right. That's right. And again, that is something that you may well, that a defense lawyer may well want to develop. Let me go to make the first 2 points.
Mr. Walker seems to have.
Walker, I'm sorry.
Mr. Fox, I may take you off your path here, but do we really have intent here? And if so, what is the evidence of intent with respect to this motion in limine? If we were to believe that respondents thought they had filed the full report with the judge, and if we get to intent through the path of aggravated neglect, what on earth is that?
All right. You are going where I wanted to go, but you are a step ahead of me. Let me come to the intent point and make a brief point, and then let me come back to it. And that is if you go to the word of the rule, it says intentionally fail to disclose to the defense. Intentionally is an adverb. It modifies the phrase fail to disclose to the defense. It's not intent to violate Brady. It's not intent to violate Rule 3.8. It's intent to fail to disclose. Now, in order to explain why that's significant, I got to go back to my first of the 2 points that I want to make about the text of the statute. And this seems to me to be an appropriate day to engage in a little textualism. All right. So what is the rule? I said statute, I meant rule. What does the rule say about what must be disclosed? It says any evidence or information that the prosecutor knows or reasonably should know tends to negate the guilt. Goes on from there. Any information that the prosecutor reasonably should know. Now, I submit to you that that is an objective standard. It's a reasonable person or a reasonable prosecutor standard. And that the Vaughn case resolved as a matter of law that standard had been met, that a reasonable prosecutor should have known that this evidence needed to be produced.
Mr. Fox, but given the trial judge's decisions after seeing the full report and the exhibits, given the positions that the appellate division took, why does that not negate the evidence of non-intentionality? Or why isn't that evidence of non-intentionality? Why isn't that evidence that these prosecutors actually were reasonable in not thinking that some of this needed to be disclosed?
Well, first of all, Judge Warren was reversed. But secondly, he was.
But the standard is at the time.
Yeah, well, but
before the Vaughn decision came down.
No, but the Vaughn decision, at no place in the Vaughn decision, despite what Mr. Little says, is there any indication that this is new law? There's nothing in there whatsoever. It took a long time to decide because this case, because of what these prosecutors did, it took 18 months before the trial was over, before there was a sentence, and then the appeal process took a long time. But there is nothing in the Vaughn opinion that says this is new law. And secondly, what Judge Morin was doing was looking backwards to see whether a new trial should be granted. And if you look at he had 4 or 5 hearings. It clearly troubled him. In my recollection, I'm sure Ms. Richardson will correct me if I'm wrong, is that he didn't actually issue an opinion. He did it from the bench in the last of the hearings. And what he essentially said was that the report itself would not have been admissible as extrinsic evidence to impeach the officer. There was no focus in his ruling on the very issue that concerned the Court of Appeals. And that issue was the powerful impeachment that came about when a man who was testifying that these inmates committed assault charged another inmate with assault. So, and as to the appellate section, I give that 0 weight. I mean, their job is to defend the prosecutions of the United States. Yes, there are occasional times that they confess error, but I think I asked the person who testified about it. His name escapes me right now, in cross-examination, and I think she said it's happened once or twice, a very minuscule amount of time.
All right, let's go to Ms. Cassidy and then Ms. Pittman, just based on who got hands up first.
Mr. Fox, in your interpretation of 3.8, and then comparing that with what the court found in Vaughn, it sounded to me like you are potentially suggesting that when a prosecutor makes a mistake in what they turn over under Brady, that in fact that equates to an ethical violation because of how you interpret 3.8. Am I hearing you correctly, or could you help me understand the distinction between a 3.8 violation by a prosecutor where they're violating their rules of professional conduct versus what a court may find when there is a Brady Brady issue on the behalf of?
All right, you are taking me to the last 2 points that I wanted to make, and let me go there first. But I still do want to do my textual interpretation here. I'm not sure I agree with you 100%, Ms. Cassidy, but I'm close to saying that. What I would say is that this rule has to be very strictly enforced, and that when a prosecutor makes a mistake, in many instances, that prosecutor should be charged with a 3.8E violation, and it's shameful that we have not done so before in many instances. And I say that for 2 reasons. These were going to be my last 2 points. The first reason is that it is so easy for the prosecutor to avoid this. All she had to do was disclose. All she had to do was take that report, maybe redact some of the names if they really thought there were security issues, or employment issues is what they originally said, and send it to the defense. That's all they had to do. So that's the first point. It's easy to avoid. The second point is that the consequences of violating 3.8E are more serious than violating any other disciplinary rule. I'm sorry.
Mr. Fox, excuse me. I appreciate that in this situation, you termed it as so easy to avoid a professional conduct violation as you're defining it today. But is it always so easy when you're the prosecutor and you're managing countless agents and countless agencies, and you're the one charged with the obligation of gathering all the reports and all the information that they gathered? when in fact some of them may or may not have even written a report. They may or may not have interviewed witnesses or told you of those witnesses. Is not your, it's always easy to avoid this, somewhat of a bridge too far, given what you're expecting a prosecutor to do in some of the cases that they manage?
I don't think so, because you go back, this is where I would have liked to have gone with intentionality, because the prosecutor has to know about the information. It can be a Brady violation if the prosecutor doesn't know, but it has to, the prosecutor has to know about it, and therefore make an intentional decision not to disclose it to violate 3.8. Go to the Klein case. The Klein case, when it talks about violating 3.8E, suggests that intentionality doesn't include an inadvertent failure to disclose. And it cites a case called Strickland v. Green or Strickler v. Green. I'm not sure if I have the name right, which is a Supreme Court case. And in that case, the prosecutor had an open file discovery procedure. But his file did not include a number of very important reports or notes from the police officer in the case, because the police officer had never given it to him. And that was found to be a Brady violation. It wasn't the prosecutor's fault, because the officer hadn't given it to him. And that's what the court in Klein cited as an example of a case where it wouldn't have been intentional conduct, because the prosecutor wasn't aware of the existence of the report. So that's my answer to your question. And the second point that I do want to make here is that the effect of not disclosing is more serious than any other violation, but Mr. Walker is not going to let me make that point.
Well, hang on, let's go to Ms. Pittman, then Mr. Walker.
Oh, I'm sorry.
Ms. Pittman's hand's been up for a while. She's been very patient. And,
Well, I'm actually going to return to Mr. Walker's earlier question, because I still don't see intent here. And in particular, here's how I view it. I want, for the assumption of my question is this material should have been disclosed. All right, so I don't want you to explain why it's Brady or Giglio. We're going to assume that it is. But Mr. Little makes a really good point, which is that you've got two prosecutors here who are trying to do the right thing. They go to the Lewis Committee, Ms. Richardson described that. They go to their supervisors, they get a late approval from the Lewis Committee to do something. So they really quickly put together a motion in limine. Maybe it's sloppy. Maybe it should have had more detail in it, but they think that it's okay. But they may think it's okay that we just got the summary down quickly, because they think they're giving the entire report to the court. And why would they intentionally lie in a motion in limine and then give the full report to the court? That would be silly. So where do you get intent on those facts?
All right, let me go back to the second textual interpretation. Intentionally fail to disclose to the defense. Doesn't say intentionally lie. It doesn't say intentionally withhold something you know shouldn't be disclosed. It says, it says intentionally fail to disclose. Now, the hearing committee got it wrong, because if you go to 58 of their report, it says these were not prosecutors who set out to violate Brady, Giglio, or rules or the rules with deliberateness, which I think is your point as well, okay? But they did intentionally determine not to disclose all those facts in the report. And Miss Dobie, Miss Dobie testified that she read it carefully. She tried to put in all this stuff, and she didn't think that she had to disclose it. She made a mistake, but she intentionally did not disclose it, and that violates the rule.
So let me ask you, the rule has a safe harbor provision where you could get an order from the court that relieves you of the duty to disclose. So are you saying that had they given the court the entire record, they didn't make the mistake, they gave all 10 pages, and they said to the court, we think there are really good reasons why we cannot disclose any of this to the defense. We don't think it's Brady, and here's the reason why we don't think it's Brady or Giglio, and we need an order from you of protection. They would have intentionally withheld And you're saying that that would be a violation?
No, I'm not, because that's specifically covered in the rule. The rule says, I'm trying to find the part, except when the prosecutor is relieved of this responsibility by a protective order of the tribunal. Now,
Well, why isn't that applicable here if there's agreement on the record and by the parties throughout this matter? Although I'm not saying the board has found this by any means, but if the respondents believe they had submitted the full report, why doesn't that negate intentionality under the rule here?
because it's not intentionality. First of all, you have to disclose to the defense.
Well, yeah, why doesn't that give them cover under the rule if they thought they were submitting the full report to the judge? And do you think they did not believe that they knew they weren't submitting the full report?
I don't have any evidence that they didn't know they were, that they didn't think they were.
So why doesn't what they did give them cover here?
Vaughn, it has to be submitted to the defense. And what the court said in Vaughn was
Under the rule. We're looking at the rule, not Brady Giglio.
I promise you I'm going there. That the rule says has to be given to the defense. And the court in Vaughn said that they did that by filing the motion in limine. And then the court goes on for pages as the inadequacies of those disclosures to the defense.
Well, Mr. Fox, I guess the respondents are arguing that they functionally fall within, leaving aside questions of intent, which I think are different than the applicability of that protective order safe harbor at the end, that this is the functional equivalent of a protective order going to the judge and filing an ex parte and under seal. And I guess why I assume think that's wrong. Well, why do you think that's wrong?
Well, I think what the rule is dealing with is a situation where, for some reason, and there's no case law on this at all, but for some reason, the obligation to disclose under Brady or whatever, the obligation to disclose under Rule 3.8, better than to say that than Brady, is outweighed by some other factor, maybe national security situation, I don't know, where the court says, because it talks about relieving them of the responsibility to make the disclosure. Now, that's not what was going on here. What was going on here is the issue was, do we have to give them the full report? Not do we have to disclose what's in the report, but do we have to give them the full report? That's what they file the thing under seal because they say that there is employment information, sensitive employment information. So they don't want to give them the full report, but they're not claiming, and nobody has claimed they didn't have to disclose what was in the report, the content of the report, which I think is what that protective order situation goes to, where you actually don't have to even disclose it. It was just, and the Lewis Committee, we keep hearing about the Lewis Committee. The Lewis Committee decides whether you can sponsor the witness. It doesn't disclose, and what came out of that was, we think you can sponsor, disclose, and litigate. Disclose what's in the report and litigate how it's going to be used, whether extrinsic evidence comes in, that sort of thing.
Let me ask the question, maybe it's a slightly different question, but it's related. This case has a couple of weird features to it. I guess one of them seems to be, and I'm not quite sure where the record is on this, and I would love your guidance, that if this really was a common practice by the U.S. Attorney's Office, and if this really was a commonly accepted practice by the court, that to sort of disapprove of that has us saying that basically the way the U.S. Attorney's Office worked in 2009 was a massive 3.8E violation. And that seems, might be, right? But it strikes me it would be extraordinary. And what do we do with that?
Well, but again, I think the issue is being distorted here. And with all respect, I think your question distorts the issue, because the issue is not whether the information needed to be disclosed to the defense. It's the mechanism, how you disclose it. Do you do it by giving them The
No,
report,
sure. But if the U.S. Attorney's Office was operating under this view that, hey, we can file this stuff under seal, and then that we punt on our Brady and 3.8E obligations to the court, and the court sort of does our job for us with respect to that. Well, so there are two questions, right? So first question is, like, to what extent is that what the record says? Because I'm just not clear on that. And the second question is, like, if that's what the record suggests, what do we do with it?
well,
Because I think the hearing committee kind of gets us part of the way there, and it's not like that's not comfortable.
well, let me try to respond. What I think that the procedure that I think that is being confused here is a situation where the prosecutor has something which is maybe needs to be disclosed, maybe doesn't, not sure, gives it to the court and lets the court make the determination. And that's what Judge Morin testified. Yeah, that was done. That's not what was happening here. Nobody disputes that what was in that report, the content of it, had to be disclosed. The Lewis Committee comes back and says, disclose and litigate. Okay, the question was how it was going to be disclosed. Was it going to be disclosed by the motion in limine, which supposedly was going to just have all the stuff in it, or were you going to give them the report? The prosecutor said, we don't want to give them a report because it's got sensitive employment information. And they say, and they represent to the court on more than one occasion, that everything that's important that needs to be disclosed is in our motion in limine. So I think that you're mixing two different kinds of things there when you talk about relying on the court. Here, they were relying on the court only for the issue of whether assuming the contents were disclosed, do we also have to give them the report?
So tell me if this is one other way of thinking it, of what you're saying, right? That perhaps the protective order, the motion to seal is perhaps an effective substitute for a 3.8E disclosure obligation for the report itself, but not for the information within the report.
I think that's right. I'm not sure.
Yeah, no, sure. Sorry.
I mean, I think that's right. I mean, here the issue was just the format of the disclosure. That's what was going on, and that's what the judge was going to decide.
Let me ask you. Oh, I'm sorry. Go ahead, Brenda. Sorry, Ms. Sargent.
Somebody's got their hand up.
Sure, yeah, it was me. I'm pretty sure I already know the answer to this. We don't have in the record any indication of how the Department of Justice's own OPR analyzed all this and came out, do we? I mean,
that we are not permitted to disclose that.
okay.
Let me ask you another question, Mr. Fox. Another weird thing about this case is the Vaughn opinion. It does seem that respondents have a pretty good point that they weren't parties to the appeal in Vaughn, even though they apparently their names were on the brief, but they weren't the party, right? The United States was the party. So, like, strictly speaking, collateral estoppel doesn't apply. And I think everybody agrees that a Brady violation has fewer elements than a 3.E violation, right? You've got to have intent. You've got to have Brady violations goes to the government as a whole, not the prosecutor as an individual. Like, what do we do with at the same time, it would be kind of weird if we reached a factual determination that is different than the one that the Vaughn court reached, just because, of course, this case goes to the court that's the same court as the Vaughn court, when we're done. I guess, how can you help us think about that?
Well, the point I was trying to make earlier about the reasonable prosecutor, the determination about what needs to be disclosed, and that is an objective standard, is that's a legal finding. It's not a factual finding, it's a legal finding. And the court has made that legal finding. And that, I think, it's not collateral estoppel. Collateral estoppel are facts that bind you. Here, it's a legal finding that this was the kind of material that had to be disclosed. So I think that part is done. So you go to the second thing, and this is what my textual argument I've never been able to articulate yet, which is that there's an adverb that modifies intentionally, that modifies failure to disclose the defense. It doesn't mean, as the hearing committee said, intentionally try to violate Brady or intentionally try to violate the rules. And the respondents play fast and loose with this. If you go to their brief, they keep saying the state of mind, but they never kind of specify what it is. I heard reasonably. They have to act reasonably today. Well, that's not what the rule says. The rule says if there is something which a reasonable prosecutor should know has to be disclosed, and you intentionally don't disclose it, you violate the rule. And we have Ms. Dobie's testimony about what they did. And we have her repeated statements after the fact about the fact that we've disclosed everything in the motion in limine. And that just didn't happen. So I'm running out of time. So let me make, I made the point about the reason this needs to be strictly enforced is that one, it's easy for the prosecutor to avoid. But the second point, and really this is what I want to close on, is that this is the most serious ethical violation that a lawyer can commit. Because the consequences of failure to disclose exculpatory information can result in a human being going to jail when they don't belong in jail. And we have cited to you material about how many people think that there is an outbreak of that. Now, it's very hard to prove what has never been disclosed. But we do know in certain situations, the prosecutors have not disclosed this information and people have gone to jail. And we have a case right here in the District of Columbia where a man went to jail for 27 years when the prosecutors failed to disclose that they had made a deal with the only witness against him in a rape murder case, and that by some miracle, the DNA was preserved in that case. And when DNA exonerated the man 27 years later and actually disclosed who actually committed the crime, because that guy was in prison for rape, although he died, prosecutors cannot allow that to happen.
Mr. Fox, can you talk a little bit about the penalty then? I mean, why is the penalty here 60 days, or why are you advocating for a 60-day penalty if the crime is so serious as you've described it?
I don't know how to come up with the right penalty for this. I will tell you that 60 days is it's me. It's no, there's no, I don't have any authority. I mean, we gave you all the authority that we have, and you see different Brady violations, they go different lengths. And some of the Brady violations are more serious than others, and that obviously should factor in. But the main thing is it's got to be a deterrent. What has to be done here is there has to be a deterrent so that a prosecutor knows that if he or she violates 3.8E, there is going to be a real consequence. 30 days is what the court said in Klein would normally apply. This is a more serious case than Klein because the stuff was clearly material from the start. And while the hearing committee says, oh, well, we don't take materiality into effect. Yes, you should take it into effect when you're determining sanction. And all the arguments from the respondents are that you'd take it into effect. That's how they distinguish all the other cases. They were more material. So it was material. And we have the false statements, the misleading statements that these prosecutors made to the judge in this case, which we didn't have in Klein. I'm not sure 60 days is enough, but I think it ought to be the minimum. And the important thing here is deterrence.
Thank you very much, Mr. Fox. David, if we could have 5 minutes for Ms. Richardson's rebuttal. Ms. Richardson?
I'm going to try and address at least 3 points that came up there. The first, I want to start where Mr. Fox ended, and he's clearly passionate about this really important social issue, but it cannot be the case that when an office has made a policy and people are following that policy and later a court finds that it's unconstitutional, that the solution is to sacrifice the junior people on the chain who were in fact trying to follow direction and gave the entire report to the judge. Rule 3.8E, I understand disclose and litigate was created in reaction to the protective order that is explicitly referred to in Rule 3.8E. And I also think, I know Mr. Kaiser, you asked about the weirdness of the decision with Vaughn and something that happens here. It has to be emphasized that there was a totally different factual record. You know, even Mr. Collins testified at the hearing. We know much more about what happened as far as giving it to the judge. The court didn't know that because it wasn't looking at intent. It wasn't looking at state of mind. It wasn't looking at the process that was going on. And there were major changes that were made in that process as a result of Vaughn. And we have hearing testimony on that. And I understand that Mr. Fox thinks there wasn't a big change in law, but if you look at the Vaughn decision itself, it heavily cites to a 2011 case, Miller, which wasn't in place in 2009. That also has to go to the state of the mind of the prosecutors here. And Ms. Dobie testified that when she wrote that motion in limine, which in many ways was quick, right? Given the timing that she was pushing for a decision over and over again, she took it, she focused on the findings as she understood was the policy at the time and pulled stuff in the report as it went to those findings. And then she gave the whole report, I know I keep saying it over and over again, to the court, right? But it cannot be a situation where every Brady violation becomes a 3.8E violation.
No one's saying, I think we're miles from every Brady violation becomes a 3.E violation. I mean, because Brady's really broad, right? If an FBI agent does something and doesn't tell the prosecutor, that's a Brady violation. No one in the right mind thinks that that's a 3.8E violation for the prosecutor, right? Because the prosecutor doesn't know or reasonably have cause to know. I guess I'm curious what you think about if you could respond to Mr. Fox's point about the effect of the filing it under seal, because it does, or maybe to the way I asked the question about what his point was, right? That I get the point of a protective order. And in cases I've had where there's been a protective order in place, it's been for security concerns, right? You get a cooperating witness, you don't want the cooperating witness getting threatened or hurt or something. But that goes to the evidence itself, not to the information. And the information here is what was in the motion in limine. And as we talked about at some length, the motion in limine was incomplete in that it didn't include the false disciplinary report, or the finding that the disciplinary report was false or inconsistent with the video. I guess I'm wondering, it looks like under the structure of the rule, the protective order would protect, the protective order exemption would protect the disclosure of the report, but you've got to turn over both the report and the information, and it doesn't go to the information. And it looks like that's where, as we've talked about a fair bit this afternoon, there was the motion in limine was substantially defective.
Yeah, I think Mr. Fox and I agree on one thing, which is there's not any case law on this. Congratulations, we're in a new area yet again. But I think that goes to intent, right? If the prosecutors here thought that by doing disclose and litigate and filing the motion to seal, that they were getting the benefit of the protective order, as well as getting the benefit of the judge, the ultimate decision maker, having the entirety of it and checking what they had. I mean, they have a safety net and a protective order. They've tried to do this in every way. You have to know the standard and the reasonableness of it has to go to the fact that there's not a finding that doing that is not invoking
Why wouldn't that go to sanction? Why wouldn't that just go to sanction? Because I mean, it can't be that to have a violation of the rule, you have to know that you're violating the rules, right? Like, and it sounds like that's exactly what you're saying. I mean, then we wouldn't have any misappropriation cases except for intentional misappropriation if disciplinary counsel both has to show that you're taking client money and you know that doing that is a violation of the rule. It may be that they were trying really hard to comply. They just messed up. They just didn't comply. They just broke the rule. It could be that a lawyer's trying really hard, but is still not competent and breaks the rule. Like trying really hard goes to sanction. It isn't a defense. And it sounds like that's what you're saying. They were trying really hard.
Well, I do think they were trying very hard, but I don't think that just goes to sanction because this rule actually does have state of mind in it, right? Intentionality.
What's the state of mind? Here it doesn't look like Mr. Fox has a point. It's intentionally failing to disclose, not intentionally failing to disclose knowing it's a Brady violation.
Well, but that goes to the known or should have known, which we've argued about given the status.
Right, but how do you have should have known, right? So reasonably should have known means the prosecutor does not have actual knowledge that it's Brady material, but should have actual knowledge that it's Brady material, and then doesn't turn it over, intentionally doesn't turn it over.
So I read the known or should have known to, I think, again, agreeing with Mr. Fox, it goes to what a reasonable prosecutor would have done. That's what the standard is here. And we know what the reasonable prosecutors thought about the information here. And I do think the intentionality goes to the entire, yes.
No, but I'm sorry, but when you look at just the structure of the rule, right, it looks like first question, there's information. The prosecutor has to either know or reasonably know that that tends to negate the guilt of the accused. And should have known means there can be some prosecutor who knows about the information, but doesn't know that it negates the guilt of the accused, right? But should, but doesn't, but should. And then that prosecutor intentionally doesn't disclose it, right? So sends over all of the discovery and doesn't put this piece of paper in the stack, or files a motion in limine with like 3 points, but doesn't include the important 4th point, and intentionally writes the motion in limine so that it includes the 3 points and does not include the 4th point. It looks like that's the structure of the rule and the intent that the rule is talking about. And the prosecutor doesn't have to know that the point that's omitted is Brady or negates the negates the guilt of the accused. They just have to a reasonable prosecutor should know that. Why isn't that the right way to read the intent in Rule 3.8E?
And it may be, but the situation here doesn't fall into that, which is we have evidence in the record on both the known or should have known. We know both of the respondents say they didn't know, right? And then we have other people at the time, both in the appellate division, their supervisors who said, yeah, at the time, we didn't think this was something that needed to be disclosed, right? So I understand that people have issue with that, but the rules tell us that there is reasonability in here, right? That there are rules of reason, and we have to look at what was happening in 2009. I also think the way you're constructing the rule puts prosecutors in a place where maybe there should be open file discovery, but there wasn't in 2009. They were doing the best that they could. And if you as a junior prosecutor, having consulted your superiors, given it to the judge, done of all of these things, still can't comply with the rule, we're creating a strict liability standard in a way.
But Ms. Richardson, are we wrong?
Ms. Larkin
Sorry.
has very patiently been up for a minute. Let's go to Ms. Larkin.
Okay.
And you're muted, ma'am. I'm sorry.
Yeah, I'm sorry, Ms. Larkin.
That's fine. Were these two junior prosecutors both working on the case together?
Yes, ma'am, they were.
So neither saw so they collaborated together, sending the information. So they both did not have intent. Is that what you're saying?
Correct. That's what I'm saying. And they did what I think we want people under the rules to do, prosecutor, non-prosecutor, which is to consult their supervisors and try and get direction. But yes.
Okay.
Go ahead, Ms. Larkin.
So are we wrong that they were instructed by the supervisors to disclose and then litigate what, if anything, could be used in the trial? I mean, weren't they told to disclose information?
And what they understood is
Kept saying that the information was in the motion to eliminate.
Yeah, and I apologize for talking over you. It's hard.
No, that's okay. I do it all the time.
It's difficult. So they were told to disclose and litigate, which at the time was kind of this term of art, which was in other cases, frankly, it was like a 1-sentence disclosure and then give the whole thing to the judge. So they actually thought they were doing more in some ways by writing this motion in limine and giving the whole thing to the judge. So that's how they understood and was the practice in the office at the time. So they thought they were disclosing and litigating and frankly, safety net of the full report.
Okay. Thank you very much, Ms. Richardson, Mr. Little, Mr. Fox. The case is submitted. We have another argument up on the docket. I know we had talked about not taking a break. Would anyone like us to take a break, recognizing that our 40-minute argument just went an hour and 40 minutes? Okay, we will take a 3-minute break. Well, 5-minute? We will take a 5-minute
3 minutes is perfect. That's perfect.
We will take a 3-minute break. Thanks very much.
Thank you, guys.
Thank you very much.
I'm not a lawyer, but this is definitely.
Mary, we're still streaming on YouTube and there are people who can see us. Who are we missing? We're missing Mary. I think Mary's here. We're missing, oh great, we've got Alyssa. Carly, are the parties, do we have the parties?
Yes, I'll let them in now if you're ready.
Thank you. Mr. Link?
Sir.
Great. Mr. Howard? First, thank you very much for bearing with us. The argument we just finished went a lot longer than I think. Okay, it is still October 22nd. We're still the Board on Professional Responsibility. And we are here in the matter of Samuel Bailey. This is board docket number 18-54, disciplinary docket number 2015 D-144. Could the parties please identify themselves for the record? Let's start with disciplinary counsel.
Miles Link, Senior Assistant Disciplinary Counsel for the Office of Disciplinary Counsel.
Thank you. For the respondent? Mr. Howard? Mr. Howard, are you there? Can you hear me? Mr. Howard?
I'm trying to get my voice together here.
We can hear you.
I'm able to hear you from, yeah, I can hear you from another system. I'm not getting you from the one that I'm on. Bear with me 1 second, please.
Sure.
Hello?
Can you hear us now?
No, not yet.
I can hear you, but you're coming through Mr. Bailey's audio.
I think that's what's happening.
Turn it off.
No.
Would it make sense for you guys to switch computers? I don't know if that's an option.
You know, everything was okay until
Isn't that always the way?
Can you hear me?
Yeah, although I still hear you through Mr. Bailey's.
You want to take this?
No, I don't know what the devil's happened here.
Here.
Well, I don't know how I can.
You may want to mute one of them.
Yeah.
Because if you're in the same room, it's going to echo.
What I think Mr. Howard's system is not working, so it might be that muting doesn't.
Okay.
Maybe I'm not sure. Mr. Howard, if you can hear us through Mr. Bailey's computer, could switching computers be an option? Can you see us through your computer? No. I think Mr. Bailey may have just muted his computer so that now we can't hear you through it. Definitely some downsides to Zoom. Yeah. All right. Whoa. Okay, Mr. Howard.
I think that's it. Can you?
Yeah. Although, Mr. Bailey, can you turn the sound off on your computer?
Sure.
and listen to the sound through Mr. Howard's computer. Is that all right?
Yes.
Right, because otherwise that happens. Okay, how's that? Mr. Howard, can you identify yourself for the record? We'll also use Nope.
Howard, and I am counsel to Samuel Bailey.
Great. Is Mr. Okay, Mr. Howard, can you say one more thing just so I can hear you?
Sure. How are you? Can you hear me now?
Yeah, great. Okay, good. So we are here on respondents' exceptions. I assume, Mr. Howard, you'll be going first. You've got 20 minutes. How much time would you like for rebuttal?
I thought I had a little bit longer. Let's say 7 minutes.
7 minutes for rebuttal. Great. Okay, so as I said before the last argument, we're on Zoom. It can be hard to talk over or hard to have two people talking at the same time. So we'll put our hands up. Please try to watch the board to see if someone's trying to get in with a question. If you're not talking, please have yourself on mute. And with that, Mr. Howard, whenever you're ready, please begin.
All right, thank you. May it please the board and council. We have accepted to the recommendations of the ad hoc hearing committee. Our first argument centers around the designation of an expert witness in these proceedings. One of the critical aspects to any proceeding, of course, is to be prepared to adequately represent your client. We thought that we had achieved this by attending the sort of pre-hearing discovery session to get some idea of who the witnesses would be. Our understanding after a direct question to disciplinary counsel was that there would be no attorneys who were witnesses. And that was, of course, critical for us because we felt that in order to prove the case from the number of documents that we'd submitted, there would need to be someone to articulate what should have been the standard. And we still,
Mr. Howard, notwithstanding the disagreement about whether or not disciplinary counsel advised you whether or not there would be any attorneys testifying, you did receive disciplinary counsel's witness disclosure, correct?
I got the witness disclosure that was about, I think, 10 days before the hearing.
Right, but did you object to the fact that it should have been provided earlier than that?
Yes, we voiced an objection at the hearing.
Okay, but with respect to the actual witness disclosure, is it your contention that the witness disclosure that was made 10 days prior to the hearing, was that at all deficient in your mind? Is that part of your argument?
Indeed it was, because the witness statement only described the name and address of the person. There was nothing similar to what I would call a 26B4 or expert witness statement to give some idea about the nature of the testimony. And so that was not clear until the witness actually testified. So there was no statement available to give any warning about the nature of who this person was. The person, at least the expert, was allowed to observe the proceedings before his testimony, and then we presume formulate the testimony while the proceeding was transpiring.
I'm sorry, Mr. Howard, can I interrupt? Are you saying that you didn't know he was going to be an expert starting right away when the hearing began?
No, I'm saying that once he was identified in the witness statement, we knew that he had been designated as an expert.
Okay.
We did not know what the nature of his expertise would be.
I'm reading from the witness disclosure. The disciplinary counsel's witness list received January 23rd, 2019. Mr. Hanna will testify as an expert regarding the standard of care and customary legal fees for attorneys handling cases like that of Mr. Laster including before relevant courts and agencies?
That was only part of what the Mr. Hanna was called to testify about. Mr. Hanna actually testified about at least what was described as the standard of care for handling employment or civil rights cases, as well as cases brought against a union.
Yeah, but sir, if it's for attorneys handling cases like that of Mr. Laster, you, as Mr. Laster's attorney, would be aware of the fact that Mr. Laster was handling both a duty of fair representation case as well as discrimination, right? In terms of he handled at least a piece of that before OHR. So where is the ambiguity in terms of the information that disciplinary counsel provided in his witness list? And also how you initially indicated that only the address of Mr. Hanna was listed, but there actually is a description of his testimony. So you can reconcile that for the board.
Well, the description that you just read deals only with fees. It does not deal with the standard of care regarding how one would handle a civil rights case or a duty of fair representation case. And so we believe that in preparation, one should have a full opportunity to explore the nature of an expert's testimony. One of the challenges, in these proceedings is that disciplinary counsel seeks to exact all kinds of information from a respondent. And disciplinary counsel has an opportunity to be able to sift through and go through in preparation for the hearing. That same level or degree of participation is denied a respondent if you only get this person's, name 10 days before the hearing.
Sir, one more question about the notice issue, and then if you can start addressing the actual testimony that Mr. Hanna gave at the hearing and what you believe, in terms of what your objections are to that. Was there a time period though? Because if you received this on or about January of 2019, Mr. Hanna, when did he ultimately testify? Was it actually May of that year?
No, Mr. Hanna testified in February.
In February. And then did you have a follow-up hearing in May at some point?
The follow-up hearing in May was to examine a witness who had been ill during the February proceedings.
Could you have moved for the ability to have a rebuttal expert testify at that subsequent hearing?
I don't believe so, because the ruling was, it was what one would say law of the case.
Sir, you might want to move, because you've limited time, you might want to move into your objections to the actual testimony that Mr. Hanna gave at the hearing regarding standard of care and what those objections are.
The testimony that Mr. Hanna gave would, I think, best be described as kind of grievance testimony. There was never a standard that was enunciated or stated to understand what is he measuring the respondent's conduct by. The only thing that was used were conclusory terms, substandard pleadings, or this didn't meet the mark, or something similar to that. In my experience, as well as from the case law, you have to have at least a standard so that everyone knows what the conduct is being measured by. Here, there was no standard. There was only criticism regarding what transpired. And that is not sufficient for a fact finder to render a factual conclusion about the nature of the alleged conduct. And so we never got that from Mr. Hanna. Secondly, Mr. Hanna never indicated that he felt that the civil rights claims that were asserted had any merit. The only claim that he felt was meritorious was at best a duty of fair representation. And when we got to that, he was critical because the date for the last occasion that the complaint that Mr. Laster had made to his union was not inserted in the third amended complaint. And so it really was not a case where there was a duty that was established and then a breach of that duty. It appeared to be only conclusory statements about either the quality, the pleadings and/or the billing. Regarding the billing,
Mr. Howard, can I ask you, which of the rule violations do you think require expert testimony? So assuming we accept your argument that a standard was not established here, which rules then basically become at issue?
I think the rules that relate all the way up through, certainly in the 1.1s, I don't think Mr. Hanner testified very much in the Rule 8, but I think all the prior rule or alleged rule violations would require expert testimony.
And if we're familiar with cases where, like under Rule 1.4, 1.5, where expert testimony is not needed, you're saying in this case, however, it would be required.
It would be required. And as an example, let's take Rule 1.5. When you talk about Mr. Hanner's testimony was that the respondent should have billed on an hourly basis at the point, I'm saying 0.1 level as opposed to 0.25. Now, I am aware of cases all over the country, some of which may say that it should be 0.1, and there are others that allow 0.25. He was never able to articulate why it was that that should be the standard in these proceedings, other than the fact that that's what he does. In this same case, there was another law firm, the Letch law firm that we've highlighted in our papers. They sent a bill in, and it was at the 0.25.
So let's assume you're right that whether you bill at 1/10 of an hour or 1/4 of an hour is a question. Don't we have, though, for the 1.5 evidence, also a forensic expert who went through the billings?
Well, the forensic expert, and that's another issue regarding going through the billing. The forensic expert interpreted the retainer agreement that, let's say, and he concluded that if one attorney was working on a matter, then the other attorney could not bill on the matter. So his testimony was not what I would call just a straight analysis of papers. It was based on his interpretation of the retainer agreement.
Well, but didn't the retainer agreement specifically provide that Mr. Laster would not be charged any additional amounts should Mr. Stewart also be co-counseling this case?
Not the way that I just can remember his name, Mr. O'Connell, not the way he had interpreted the agreement. What was meant was there would not be any type of additional, I think the term that was used was cost associated with Mr. Bailey's participation, which pretty much meant, as the respondent testified, is that there would not be another, let's say, retainer fee for Mr. Bailey. Whatever was paid, that would be a part of the compensation that both Mr. Bailey and Mr. Stewart would receive.
I guess I'm sorry to go back to Ms. Pittman's question. Assuming the expert testimony sort of falls, right? And I guess what that means on your argument, as I understand it, is that then the sort of 1/4 of an hour, 1/10 of an argument testimony also falls, right? Does that take care of does that knock out the entire 1.5 issue?
Well, the other part I think that is included with that is this. In the discovery or production process, there were a number of documents that were submitted on a thumb drive to disciplinary counsel. Those documents had all of the information as well as emails that were related to support for billing. And Mr. O'Connell's testimony did not embrace either a review or rejection of those documents. Now, the only pushback that I'm aware of when it came to the documents that were submitted is that the emails were printed from my computer. They were electronic files, and as opposed to Mr. Bailey's, let's say Outlook, it had the Outlook from my computer. And the reason it did is because I received the electronic documents, and once I, downloaded them from my computer, they had my, email identification on it. But certainly, I, wasn't involved in the case then, and so I was trying to explain to disciplinary counsel that they were not, emails from my computer, but I just downloaded them and forwarded. And so therein lies why the volumes of documents that were submitted were had to be redone to reflect that they came from Mr. Bailey's computer.
Right. So if we're out of time, unless there are questions from the board, why don't we go to Mr. Link, and then we will come back to Mr. Howard for rebuttal after Mr. Link speaks. Go ahead, Mr. Link, when you're ready.
Thank you, Mr. Chair. Before I begin my argument, I'd like to correct 3 small typos in our brief. I apologize for the errors, but on page 5, line number 3, the number 6 should be 4, and that's a reference to page 4 of the hearing committee report. On page 21, the section heading respondent violated rules 1.4A and B, the S that appears after A should be deleted. And on page 22, 3 lines from the bottom, the sentence references to the hourly rate set forth in a matrix prepared by the Civil Division of the U.S. Attorney's Office. After office, 2 words were inadvertently deleted. Those 2 words are irrelevant. So the sentence reads, references to the hourly rate set forth in a matrix prepared by the Civil Division of the U.S. Attorney's Office are irrelevant. I'd like to first respond to the question of the expert witness. Learned counsel has referred to Rule 26B4 of the Federal Rules of Civil Procedure. Those rules don't apply in a disciplinary hearing, and they never have. And no counsel, whether respondent's counsel or disciplinary counsel, is obligated to distribute a 26B4 statement. By respondent's counsel's own statement, he received notice at the very latest of the expert to be called by disciplinary counsel 10 days before the hearing was scheduled. That was ample time, and he had the name and the address information, and he knew what the expert was going to testify on. That was ample time for him to contact the expert, to interview the expert, and to seek expert testimony of his own. And if he couldn't do it for the February hearing, he certainly had time to do it for the May hearing, which by his own testimony, that hearing was called to hear evidence from another witness. Had he called an expert, that person could have testified then. So there was no prejudice to respondent with respect to calling the expert witness.
So, Mr. Link, you're saying that had he raised at the hearing that he wanted to add a witness and it be an expert witness, that ODC would not have objected to the late naming of an expert?
I can't say that we would or we wouldn't have. The point is he didn't. And, okay. And had he done so, and had we objected on the record, that might have been the basis for an argument here today, but he never did. And so that never happened.
Mr. Link, can I ask you to talk about something Mr. Howard talked about sort of toward the beginning of his argument, which is it does, I mean, it seems like he kind of has a point that if you show up at disciplinary counsel's office and you review the file so that you're ready for the hearing and you're ready to go, and then disciplinary counsel adds more stuff later, that's, I don't know that that's a rule violation, but it does seem kind of lousy. And well, I'm wondering if you can talk about that.
Certainly. Mr. Howard's testimony, or excuse me, statement is that he heard at the latest 10 days before the hearing, when the witness lists were distributed, that an expert would be called. There's no record as to whether there were any conversations prior to that, or what may have been discussed or disclosed prior to that. My point is, had respondent objected or been surprised or felt the need to reorganize their presentation based on the expert, that was something they could have presented to the hearing committee, and they did not. And so here we are years after the fact to conjecture what might have happened or what might have transpired, whether we would have objected, whether we would have concurred, is, with respect, beside the point. The point is—
Well, Mr. Link, aren't you, I think the focus, and I don't want to put words into the chairman's mouth, but I think the focus of Mr. Kaiser's question was, well, what is disciplinary counsel's duty in this regard, where they make a file available for respondents counsel. Respondents counsel goes there, looks at the file, believes that they're looking at a complete file, and then after the fact, because at that point disciplinary counsel hadn't gotten their ducks in a row and named an expert, they hadn't put that information in there. That's fine. But what about after the fact? The question that I want to ask you is, would you agree with me that had disciplinary counsel named Mr. Hanna as an expert prior to Mr. Howard reviewing the file, would there have been information in that file related to Mr. Hanna?
I don't know if there would have been information in the file related to Mr. Hanna.
Resume, something like that.
There might have been, had he been named prior. That I mean, again, ex post
but didn't you use the resume as an exhibit at the hearing?
Yes, but
so that would have been in the file, right?
That's correct.
So if there was information that should have been in the file, or that would have been in the file had he looked at your file at a late date, which might have also affected him, doesn't disciplinary counsel have a duty to inform respondents counsel that, hey, we added some additional information in there, you might want to take a look at this?
We did inform counsel that we had added an expert witness. We informed him of the expert's name. We informed him of the expert's contact information.
That's not my question. My question is about whether or not the file was supplemented. The fact that the file now contained additional materials that was not otherwise available at the time that he reviewed it. Do you have a duty to inform respondents counsel of that?
If the question is, do we have a duty to inform respondents counsel, having added an expert after the original file was produced, that the expert's bio or resume is not included in the material he disclosed, we can certainly do that, or respondent can certainly ask for that information. There was no attempt by our office not to provide information to respondent that respondent was entitled to, and respondent never sought that information prior to the hearing. And again, by respondent's own testimony, he had more than a week to review that, to consider that, and to decide what action he wanted to take.
Well, can I get to the substance of Mr. Hanna's testimony? Because I think Mr. Howard has a pretty good point here, which is that when you have an expert who's going to testify on standard of care, the expert is required in the first instance to explain what the standard is that they're judging the conduct or the negligence against. And that generally you have to have some sort of like source that you can talk about, whether it be a manual or a conference or a textbook, something that you can cite to say, I know the standard, it's not just my personal opinion. So I have two questions for you. A, is that case law that I'm so familiar with in, say, negligence cases equally applicable to a standard of care expert in a disciplinary case? And I'd like, if you have some case law citations to that, that would be great, whatever your answer is. And then two, can you cite to anything in the record here in which Mr. Hanna does state, here is what the standard is, and here is the source of that material?
I don't believe Mr. Hanna stated, sort of distinguished between the inadequacy of the pleadings and filings made by a respondent and his co-counsel in the district court, and his view as to what an adequate pleading, what an adequate, for example, the third amended complaint, what an adequate complaint would look like. His testimony was that as an experienced litigator in this area, as an attorney who was, because of his experience and expertise, qualified as an expert. In fact, experts are entitled to give their opinion. That's why they're called, that's why they're qualified.
That's true, but that's true, but it's not, right? I mean, I can take you directly to cases that talk about there's two things. There's the threshold requirement for qualifying them as an expert, which is, I know something about this topic. I have certain degrees. But that only gets you qualified as an expert. It doesn't allow you to give standard of care testimony. There you must state the standard is X. This is what I'm judging him against. And whenever it's just a personal opinion, it's nothing more than I have experience, courts routinely say that's not enough.
What Mr. Hanna did testify was that the quality of the brief, the quality of the complaint that was filed was as if it had been filed by a pro se litigant, and that it was in fact without legal analysis, it was repetitive, it was duplicative, and those factors indicated how far they diverge from what a standard or meritorious complaint should have been.
Isn't that no different, sir, than expressing an opinion about any pleading? Like, you don't have to have Mr. Hanna, who supposedly had this expertise in labor and employment law, testifying about the adequacy of the complaint. I'm reading from his testimony at page 372, and he says, and he's talking about this third amended complaint, and he's complaining about the fact that Mr. Bailey decided to include all this information, what he says, going back to the beginning of time, and facts that may not necessarily be, because of statute of limitations purposes, may not be operative, but certainly one could easily make the argument that they're there for background. And he says, and here we're going to the beginning of time and doing what a pro se plaintiff did and does and did. A lot of complaint is similar to what Mr. Laster filed previously. You're basically putting together a whole bunch of facts, throwing them against the wall and hoping that something sticks. Sir, in my experience, I could name you 100 attorneys who do this exact same thing, but that doesn't mean that they're breaching the standard of care. That's just their style of litigating. So where is the standard of care that Mr. Hanna testified to with respect to the specific practice area of labor employment and how Mr. Bailey's conduct breached that standard of care?
Thank you.
You could point to me that in that testimony.
In this case, this was, again, the third amended complaint that the respondent and co-counsel had filed. It was their first filing, but it was the third amended complaint, and it was filed in the face of motions to dismiss by the defendants. And so the complaint, in order to sustain itself under the federal rules, had to meet a certain level of credibility in order not to be dismissed in light of the status of that litigation.
And that's a great point, but that's a great point that I also wanted to point out, is that there's a lot of testimony from Mr. Hanna that said that the court should have and could have dismissed this complaint, right? But you don't disagree with the reality that that never happened. And in fact, whatever was filed by Mr. Bailey on his behalf ultimately led to a substantial settlement.
No, No, I don't buy that conclusion. What was filed, what the court, I'm sorry, what the court did, in fact, the court invited the defendants to file motions to dismiss, and then the court referred the matter to mediation. And it was that which led to a settlement, not a settlement that respondent and his co-counsel recommended. They recommended essentially a pittance settlement, and the complainant, Mr. Laster, refused to accept it. The court, and then dismissed his counsel. The court appointed other counsel who came in and got a much better deal for this.
Right, but in between the filing of the amended complaint and the opposition and motion to dismiss, both of which were filed by the respondent, right? There was no other pleading that or motion or document that was filed by any other lawyer in this case, and you can correct me if I'm wrong, between after what they had filed and what led to the settlement. The settlement itself is a separate issue. What we're talking about is the quality of the work that was put forth in front of that court. How can you take issue with that if ultimately it led to a settlement? If the documents were so deficient as disciplinary counsel claims, right? Then you could make the argument that the lawyers who settled the case on behalf of the other side, on behalf of the defendants in that case, would have been like, oh, we have a great shot of winning this case. Why would we want to settle for a substantial amount? But it's not like the Lash firm actually filed anything or did anything differently. They might have handled the mediation differently, and certainly it seems like they were more successful in that regard. But the actual pleadings and documents that are at issue, there was nothing else filed that led, after the fact.
Well, one filing that is not germane to your particular point, but which did take place, was the filing by the annuity fund. They moved a motion to dismiss because they had not been named in the third amended complaint, and they responded, and his co-counsel never filed a response to that. We don't say that their failure to file a response to that is necessarily evidence of incompetence. It was fortunate that, in fact, there was no valid claim against that defendant. And so that defendant, but what it is evidence of is that their failure to take proactive action and steps in this litigation. They could have, in fact, they could have moved to dismiss that defendant, or they could have filed a response agreeing.
But that defendant was never included in the third amended complaint, right?
That's right.
There was never any claim against them. So couldn't you argue that the incompetence was on the annuity counsel for filing a motion to dismiss when they weren't even named in a complaint?
You could argue that, but you could argue that they were being proactive and looking out for their client to make sure and to underline that their client was not involved in the proceeding. But going back to whether the third amended complaint led to the settlement, no, with respect, I think the court in its discretion decided that it would give the parties a chance to mediate the claim because it, frankly, I suspect, did not want to dismiss the claim that Mr. Laster had initially.
Sir, that's a lot of conjecture, though. That's a lot of conjecture of what you think the court did and didn't do. The reality is that you have a situation where they filed an opposition to motion to dismiss. They filed a third amended complaint that was both of those. I've reviewed those pleadings. They seem fairly substantive to me. They don't seem like they're very bare bones. We might take issues with corrections here and errors here, but they were substantive motions that led the other parties to put forth a substantial settlement through mediation. Whether or not the mediation was the product of respondent or not, that's separate, right? We know that it wasn't. We know that it was the other firm.
I note that, first of all, again, whether we're talking, it's also conjecture to say that the filing of the third amended complaint led the defendants to want to mediate and settle the case. As you well know, often parties just want to get things settled and just close the case out. Also, finding of fact 51 by the hearing committee made their own independent evaluation of the pleadings, completely apart from the testimony of the expert. And they said they found them deficient and they found them to be, in fact, a violation of Rule 1.1.
So we're a group of lawyers. Can we also do that?
I'm sorry?
I was gonna say, we're a group of lawyers. Should we, so if that's on a cold record, reviewing it, can't we also then review the pleadings to determine whether or not they're sufficient or not?
Or to ask a question, the same question perhaps in a slightly different way. Does disciplinary counsel take the position that you need an expert every time you've got a 1.1A violation, every time you're trying to show that a lawyer was not competent?
No, we don't take that position. We think having an expert is good practice, but it's not necessary practice in all cases. We think, Ms. Pittman, with respect, I think the board's role at this point is whether there was substantial evidence to support the hearing committee's findings, and we think clearly there was. We think our case was proven by clear and convincing evidence. We may understand that members of the board may disagree with some of the findings of the hearing committee, and had you sat on the hearing committee, you may have come to a different conclusion. But if there's substantial evidence to support the hearing committee's findings, we think that's sufficient.
So, Mr. Link, can I ask you, in this case on this record, if the expert testimony were not there, would there still be substantial evidence to find that there was a violation of the duty of competence?
If the expert witness testimony were not there, I suspect with some confidence there would have been other testimony introduced reviewing the document itself.
On the record you got here, if you hadn't put in other testimony, just imagine that the transcript exists, the expert stuff is gone. Is there enough left over to find 1.1 problem, or is that decisive on that rule violation?
The hearing committee in their finding of fact 51 concluded that there was. And so we think the hearing committee got it right. If I may, I would like to go to the billing issue. And I note that in the reply brief filed by respondent, they said that paragraph M in the fee agreement complied with all the requirements of Rule 1.5e when you have attorneys from 2 or more firms working together. And I refer you, we appended to our brief the fee agreement, because we wanted the board to have before it its clear deficiency. And I want you to look at paragraph M and compare it to the requirements of Rule 1.5e. For example, there's no division of responsibilities set forth in paragraph M. Who's doing what? We know that Mr. Stewart was brought in as the subject matter expert in this case, and respondent was presumably local counsel, but there's nothing to advise the client of that. There's no explanation in paragraph M of the division of fees. Is Mr. Stewart getting 60%? Is respondent, Mr. Bailey, getting 40%, or vice versa, or 50-50? That's nowhere to be found. Do the attorneys, is there a joint representation? Do they assume joint responsibility for the representation, or are they each responsible for separate parts? There's nothing in paragraph M that answers that question. And finally, it says that counsel will, meaning Mr. Bailey, will file a motion pro hoc vice on behalf of Mr. Stewart for temporary admission in the DC bar. That is factually incorrect. Mr. Stewart was not looking for reciprocal admission in the DC bar. Pro hoc vice admission was to the U.S. District Court for the District of Columbia.
So, can I ask you a question though? Which is, we're out of time, but I really do want to ask you about the ACAB decision here. And how you think that plays into the 1.5 issue, particularly when, as far as I can tell, the rationale of the ACAB decision is not in the record.
Ma'am, Ms. Pittman, the rationale of the ACAB decision is not in the record because ACAB doesn't really provide a lot of rationale for their decision. The hearing committee concluded that despite the ACAB decision, restitution by respondent was appropriate should respondent seek readmission to the bar. And in Ray Rodriguez-Quesada, the Court of Appeals has held that in fact restitution is appropriate, even if in that case a complainant had lost a claim in civil court against a lawyer seeking restitution of fees. Okay. The ACAB decision and the disciplinary proceedings are entirely separate. Disciplinary counsel was not a party to that proceeding. This board was not a party to that proceeding, and we're not in privity with any party to that proceeding. We don't know what they considered. We do know that we are considering in detail and great depth the inadequacy and the failure to comply with both 1.5a, the reasonableness of the fee, and 1.5e, which clearly they did not comply with. Okay. So we think restitution is appropriate. We think the ACAB decision is informative. It's informative, but it's not dispositive.
Okay, thank you very much. Let's hear from Mr. Howard. I don't remember how much time is left on rebuttal. David, hopefully you do. Excellent. David remembers. Thank you, David. Mr. Howard, when you're ready.
All right, thank you. I'd like to touch on a couple of matters relating to the mediation. Mediation had commenced in these proceedings long before the judge entered an order. If you look at the billing statement that was submitted to Mr. Laster, and by the way, a billing statement was submitted to him in August of 2014, as well as another one in February of 2015. That statement indicates that there were 2 mediation sessions before the court entered an order for mediation. So that was not something that the court injected. The parties had already begun mediation. The second part is when we mentioned the Letch Law Firm, the primary reason for that is the Letch Law Firm was not the firm that negotiated the settlement. The settlement was negotiated by two pro bono counsel from K&L Gates. And if you look at Mr. Laster's testimony carefully in the cross-examination, you'll see that not only was there some, let's say, pushback on what occurred during the settlement negotiations, but K&L Gates, the attorneys from K&L Gates, sought to protect Mr. Laster from the Letch Law Firm in taking over the money that was a part of the settlement. The Letch Law Firm did absolutely nothing and walked away with over 45% or over 40% of the proceeds. Now, that fits in because at the time that the matter was addressed by ACAB, ACAB knew how the money had been parsed out. And so one cannot rely on the ACAB decision to say that that shows that the respondents overbilled Mr. Laster. All it shows is that there was a lot of money taken out of the settlement, and ACAB tried to find some happy medium so that Mr. Laster wouldn't be out of more money. But it's certainly not indicative of the merits of whether or not there was a rule violation. And aside from that, I think we sort of rest in our papers. The one thing that we do ask is that the points that we've advanced about how the testimony should be considered, what documents, are relevant, we would just ask that the board review them, because we don't believe that the hearing committee read the documents. The only reference is to 1,000 pages, but those pages have information, and we think it's only fair that the record be accorded the kind of respect that it deserves. Thank you.
All right, thank you very much. The case is submitted. Thanks.